SJC-13108, Ofer, Nemirovsky v. Daikin, North America, LLC.
Okay, Attorney Fleming.
Good morning, and may it please the court. Mark Fleming, together with Felicia Ellsworth, on behalf of the appellant, Daikin, North America. A component seller warrants that its products are merchantable. It does not warrant that they are immune from damage caused by a defect in another product over which the seller has no control. If a component is placed into a larger system that has a defect, the component seller does not become liable for the whole system.
How's it a component part? The coils are supposed to go into one system, and if they don't work in that one system, they don't work at all.
Justice Lowy, the components, the replacement coils in this case that Daikin North America supplied did work. Many of them are still working in the system today. The only evidence—
They don't work with the system and the styrofoam pans, and they don't. And the issue is whether or not the system's going to work. They don't work in the only system they were intended to be used in.
That's not what the evidence shows, Justice Lowy.
What does the evidence show then? Because that's how I read it.
So the evidence shows, Your Honor, that the replacement coils that Daikin North America provided, only 3 of them corroded. They corroded years after they were supplied.
Yeah, but that's not the point, right? Your legal argument. Go back to your legal argument and tell me, explain what the record evidence was as to why it wasn't intended for that system.
Well, they are intended for use in that system, and the implied warranty of merchantability asks, were they merchantable at the time that they left the seller's hands? These components were installed.
They have to leave the seller's hands and still work in the unit.
And they did, Your Honor. The majority of the ones that were provided did work, and as of the time of trial, we're still working.
Okay, but this
3 of the replacement coils
must have been argued a lot at the in front of the jury, correct? That there were only a couple coils that went bad, and that's not your fault.
Absolutely, but the point is, the question is the reason why they failed. Did they fail because there was something at the time that they were sold that made them not merchantable, or did they fail for another reason that was outside of the control of the component seller?
And so
here there's
if
no
the
dispute.
Component seller sells a product to put into another product, say it's an automobile, and I'm going to sell you a tire, and it fits your car. And it's the only tire that fits this particular car, but there's a defect in the way the wheels work in the car. And I've targeted that particular car. Shouldn't I know that?
Well, the question is, even if one does know that it is going into a particular car, does the component maker, the tire maker in your hypothetical, have a responsibility to become not a tire expert, but also a wheel or a car expert? And no court has suggested that that is the responsibility of the component maker. In fact, every court to have addressed this, as the amici point out in detail, and as the Davis court in the Supreme Court of Tennessee says, no court has suggested that there's a responsibility.
But this defendant was on notice, correct? Wasn't there evidence in the record that there had been another complaint in the area?
Not at the time of the sale of the replacement coils, but even if there was, in the Cipollone case in the First Circuit, which applied this same rule, the seller of the dock lift knew what FedEx was going to do with the dock lift, but it wasn't responsible for the fact that what happened then was problematic and caused injury because of the interaction of a different component with the dock lift.
You could use
Same
a
thing.
dock lift like that maybe for Amazon too. You know, that dock lift wasn't built for FedEx.
It was, Your Honor. It was.
I don't mean in this particular instance. I mean that it's not just a dock lift that's used for FedEx. That dock lift has application beyond one industry, beyond one circumstance. Here, the coil serves one function, and with the type of drain pan that you have, the one function that it exists for, it doesn't work.
Well, there are 2 answers to that, Justice Lowy. Even in situations where the replacement part was for a specific machine, like the Crossfield case out of the 8th Circuit, where there was a replacement chain for use specifically in Strickler DeMoss pork processing machines, the fact that the chain in itself had no defect meant that the chain maker had no liability, even though it was the chain that failed when it was installed in the pork processing machine.
Assuming the component part, I'm right here.
Yes, Your Honor.
Assuming that theory is applicable here, Why isn't it waived in this case?
Oh, it's certainly, most certainly preserved because, I mean, if for no other reason than the Superior Court decided it twice. Once in the pre-judgment 93A decision, and then once again in the JNOV
And
decision.
so what did the judge in the trial court or the motion practice would say about your particular argument about it's the coils, not the machine, it's the machine, not the coils?
Well, that was not disputed at all. The judge in the
So the
JNOV decision.
component, so what'd she say to your component parts argument?
Well, so the judge made two exceptions to the argument, to the doctrine, neither of which is supported. In the 93A decision, the judge said that the rule didn't apply to components that don't function on their own and are not standalone products. We explain in our brief that we think that's based on a misreading of the chip-alone case, and there are numerous cases refuting that view. And neither the plaintiff nor the Superior Court cites one going the other way. Numerous cases where there are products that were made, like the tire in Your Honor's example, where just because the tire fails doesn't mean that the tire maker becomes responsible for the rest of the device or the integrated product simply because the tire is not a standalone product.
should we
The
be-
second exception.
And your second point?
The second exception was that the replacement coils were designed specifically to work with the larger system. But there, the rule applies perfectly well in that case. Like I was discussing with Justice Lowy, the Crossfield case says that. The estate of Thompson versus Kawasaki case says that. It was a steering damper designed for a specific Kawasaki motorcycle. The Childress case in the Sixth Circuit involved a hydraulic valve created for a specific log splitter. The fact that the component seller knows what the destiny of the component is does not create a responsibility for the component seller to figure out
So
whether
you,
there's something
this
wrong
was
with
a,
the
this
overall
was a
system.
defense that was raised in your answer?
Well, this was an argument made in the directed verdict motion, in the post-trial 93A motion, and in the JNOV motion after judgment, and the Superior Court ruled on it and did not find any waivers. So to
I'm
the
sorry.
extent,
Yeah, no, I'm sorry. But was it something that, was this part of the answer to the complaint when it was?
well, I mean, the answer certainly was that, I don't know that we use the words component parts doctrine specifically, but we certainly would have said, and it was not disputed, that the coils themselves had nothing wrong with them. The entire trial, and the entire theory of the case from their plaintiff's expert, Dr. Eager, was not that there was some way that Daikin North America should have designed the component parts differently, the replacement coils differently, that there was some manufacturing defect in them. There was no suggestion whatsoever that the replacement coils had anything specifically wrong with them. The theory of liability here was, as the colloquy has been indicating, based on these styrofoam drain pans, which Daikin North America did not make, did not sell. They were sold to Mr. Nemirovsky in 2008 when Daikin North America did not even exist.
Then it was
There was-
Daikin Americas, right?
It was DACA, Daikin AC Americas, that sold the original system in 2008. There was a claim brought against them. It was dismissed under the statute of limitations.
Did you use the words component part doctrine in the directed verdict motion? Because I can see you not using it at the answer stage. Was it in the directed verdict motion?
Well, not in those words, but we're not required to use those words in haec verba to raise
So
the point.
how was that theory articulated in other words?
If I may, it was in the motion. So this is volume 1 of the appendix, page 471, footnote 1. Plaintiff presented no evidence that the replacement coils are themselves defective. It was then argued orally, volume 3 of the appendix, page 106. And then the Supreme Court ruled on this on the merits, albeit cursorily, volume 3, page 112. It was then repeated at the directed verdict motion at the close of all evidence. So what I just gave you was the directed verdict motion at the close of the plaintiff's case. At the close of all evidence, we renewed it orally, volume 3, page 141. The court recognizes we renewed all our points orally. Our 93A brief, again, before judgment.
You reviewed you basically argued your product wasn't defective, but you didn't make the second part of the argument. The component, you didn't make the express argument based on component parts. If the component part works and the system fails, you're protected, right? You didn't go the next stage. You just argued consistently that your product wasn't defective, right?
Well, we argued that consistently, certainly. And
But you
by the
didn't
time
do
we
the
got to the
second part.
93A motion, we were citing Chipolone and Freitas and Mitchell. I don't think we are required to cite.
Can I turn you for a second to comment E? Do both sides agree that the third restatement is the best guide for this, or is there a debate on that too? Because the third restatement expressly addresses this issue about integration, right?
Yes,
But it doesn't do it quite as simply as you do it. It says when the component seller is substantially involved in the integration of the component into the design of the integrated product, the component seller is subject to liability. And then it goes on, substantial participation can take various forms. The manufacturer or assembler of the integrated product may invite the component seller to design a component that will perform specifically as part of the integrated product. Did that happen here?
No, there's no, well, there's
So,
no evidence
I mean,
of that.
you're a subsidiary of this other company, right?
I-
Do we fit within comment E?
No, I think we fit within the general rule of comment E, which has been applied by numerous cases. I mean, to be clear, with regard to this affiliates point, I mean, let's
Well,
assume
I'm
that
just trying to, I'm just saying, I mean, a lot of thought goes into these things, these restatements. They're focused on this component part argument, which is guiding the case law here. But it's kind of a fuzzy standard in here. And I'm just trying to figure out, do you win if we apply comment E, or do you lose if we apply comment E?
I certainly don't think we lose, Justice Kafker, because I think even if it were the same company that sold the original system in 2008,
Well, but is
and
there
then
back
sold-
and forth between the two? Are the groups talking about how the coils work in this system? Are they working together on this point? I'm just trying to understand that, because you're both adopting kind of an all or nothing thing. If our component part works, we're off the hook. They're arguing, nah, that doesn't work that way. But it seems like the restatement is much subtler. It basically will take you off the hook if you weren't involved in the overall design, but it won't if you were.
well, so let's be clear. Daikin North America did not sell the components directly to Mr. Nemirovsky, right? It sells them to wholesalers and retailers like Daikin Applied. And Daikin Applied is the company that was serving the actual product, and the verdict against them was significantly lower, just limited to the value of the actual coils, which is another problem with this judgment. But I'd like to, I think if I may, answer the question by pointing out that even if you had the same company that had sold the system originally in 2008, and then sold replacement coils in 2014. The sale of replacement coils does not somehow reactivate the statute of limitations on a claim for the original system. That doesn't mean the manufacturer escapes liability altogether. It just means that the implied warranty at that point has lapsed, that the claim created by the legislature is no longer valid. So that I think is a fortiori the case when
Well,
you're
I'm
talking
trying-
about two different companies.
Is the statute of limitations driving this thing? Because it doesn't sound like anyone thinks the styrofoam, whatever it is, worked. You can't, the claim can't be based on the styrofoam because it's the statute of limitations. Is that why we're focused on the coils?
I mean, to be clear, we think the styrofoam pans work just fine. And in fact, most of the
Yeah, but
providers in the industry do
that
that.
one you lose
But-
on.
No, for purposes of this appeal, we accept that the jury could have believed Dr. Eager on that.
Right. So
But
So I guess, is the styrofoam out of the case because it's of the statute of limitations? Is that why I mean, it just seems like there's something artificial about all of this, which is that the coils work pretty well, but not with the styrofoam, which works pretty poorly. But is the statute of limitations driving the fact that we're not focused on the styrofoam? That's out of the case? Is that?
I mean, to be clear, once again, only 3 out of the 17 replacement coils had failed at the time of trial and were
I
replaced again.
understand.
So many of them, in fact, most of them do work with the styrofoam. To the extent there was any problem with the styrofoam, yes, that claim was thrown out by the Superior Court judge on the statute of limitations. And we think that's the subject of the cross appeal, which I'm happy to discuss. But I think that judgment was completely correct. Because no claim.
Because if we were arguing about the styrofoam, you'd have a really bad case. Because the styrofoam, there's evidence from an expert that it's defective. And when you've got this defective part, but again, I'm taking you off track, but
Well, I don't want to concede I'd have a bad case if we were arguing about the styrofoam. I think we just have a different argument. And when we'd be attacking the expert's testimony is completely unsupported by any scientific theory that's reasonable. We're not making that argument because this case was never about the styrofoam, at least the case against Daikin North America, because Daikin North America didn't choose the styrofoam, didn't make it, didn't install it. It was there and on the scene long before Daikin North America even existed as a corporate entity. So that cannot be
Counsel?
a basis for a breach of the implied warranty. I'm sorry, someone was speaking.
That was me. I'm sorry.
Thank you, Your Honor.
And the reason I was jumping in is because in response to Justice Kafker's question about why we're not here about the styrofoam pan, and you had said the following, and I'll get this wrong somehow, but you had said, the subsequent sale of the coils does not somehow reinvigorate the statute of limitations, which has lapsed, right? Something to that effect is what you said.
I'm happy to agree with that. Yes.
I understand that footnote in your directed verdict motion to be saying exactly what you just articulated in oral argument. How is that the same as the components parts doctrine?
Oh, I think component parts factor or component part doctrine or the rule limiting component seller liability is simply shorthand for the principle that you can't hold someone liable for selling a part that was not defective.
Which is
at
a
the time.
different point than re-upping the statute of limitations. Which
Well,
is
that
what
is
this footnote is attached to a section in your directed verdict motion about the lapse of the statute of limitations, because there's only economic harm.
That's a policy argument explaining why the requirement of proving a defect in the component sold or the component seller doctrine, whatever you want to call it, is the correct approach to the law, including in this circumstance. Because a different approach, the approach the Superior Court took and the approach that the plaintiff is recommending here, would have the effect of lengthening the statute of limitations or reviving it potentially indefinitely. That's not a different argument. That's not a different point.
Well,
It's
it's
an
I mean,
additional.
I have a part that I sold. I have a system I sold yesterday. The statute of limitations is still live. And then party B has a component in that system. I mean, those are two separate arguments. The component parts doctrine might save party B, but my statute of limitations for selling the whole system is still live. I understand your argument in footnote 1 of the directed verdict motion to be saying you can't revive this dead statute of limitations because I happen to sell a non-defective coil later on. That's a different argument than the components parts document. It may be that the judge went ahead and didn't conclude that you waived it, but that's not the argument you're making in the directed verdict motion.
Well, I think it's the same argument, but what I think does not matter because, as Your Honor points out, the Superior Court, even in the face of a waiver argument belatedly by the plaintiff, did decide this issue. And I think it's sufficiently preserved for appeal as long as it is pressed or passed upon in the trial court.
And
it
what's
was
your
clearly-
best case for that legal proposition?
I don't have one as I stand here, Your Honor, but I'd be happy to provide one.
Is
It's-
it in your reply?
I don't think it is. In the reply, we certainly point out that the Superior Court decided this issue and that notably it wasn't.
I can do that. I
pressed
can
in
do the legal
our
research.
opposition.
I can do the legal research. I was
Fine,
just
Your Honor.
wondering if you had pointed it out since it's so important.
Speaking of looking for things, can you just before, I don't want to interrupt you, Justice Wentland, but before your time is up, can you either send me a letter or and tell me where I can find volume 3, 141 in the record appendix? Because I'm not finding it. So, but you don't have to take time now. You can send me a letter. or
Volume
send us a
3,
letter.
And
Volume 3, page 141.
That's what you cited about what do you call it?
Volume 3, page 141. It has manuscript transcript on it in the top left on page 2194 of the transcript, beginning at line
Of
16.
the transcript, but the transcript is not the entire record before us, right?
Well, it's the entire transcript is before
It is
you as
before
are the
us as part of
exhibits.
the record appendix?
Yes, it is, Your Honor.
Okay.
Volume 3, page 2194, beginning at line 16 is renewal. Now, to be clear, we renew all of our points at the close of all evidence as we were required to. There isn't a specific discussion of this point. The specific discussion came at the directed verdict argument at the close of the plaintiff's case, and that is on volume 3, page 106, page 2073 of the transcript. And there's the discussion again of the fact that the coils themselves are not defective. Again, the fact that we
lose you,
expanded.
can I ask you to address the misrepresentation?
Yes, Your Honor.
And I'm focused on the damages point on that. If we find there's the misrepresentation is established, what damages are properly calculated based on that and what are not?
I think it depends on which statements you find are the misrepresentation. And this is important because of the timing, because there are problems as to each one. For some of them, there is no proof of reliance, and for the reasonable reliance. And for those, there should be no damages
Let's
at
put
all.
those aside for a moment then. What about all the way back in January 2014, when the defendant knows that the situation is not environmental and doesn't tell the plaintiff?
I think, Justice Lowy, you mean January 2015, and that is important. That's when Mr. Hastings' site visit comes back with that notation on it. That's January 2015, and that timing is critical because the only statements that are asserted to be wrong, where Daikin North America said we think these are environmental causes, were in May and June of 2014, months before that statement was made. And there is no evidence, the Superior Court didn't cite any, and the plaintiff doesn't cite any, that at the time those statements were made, May and June 2014, that Daikin North America had no basis to know that that was an accurate statement.
How about knowing, based on information they received, from Vona or whomever, that the problem here is not environmental, it's not specific to this particular home, and there's no proactive effort to get back and let the plaintiff know that?
Well, the information from Mr. Vona did not suggest, and certainly didn't rule out the possibility of it being environmental. When these coils fail, they tend to fail in clusters. And so the fact that Mr. Vona was having trouble and Mr. Nemirovsky was having trouble didn't rule out the possibility of them being environmental. And the plaintiff doesn't argue otherwise. What the plaintiff argued as to Mr. Vona's statements was that Mr. Nemirovsky specifically asked, are there any other problems in New England? And there were statements made that Daikin North America didn't know of any other problems in New England. Let's assume arguendo that that was incorrect. There is no proof of reasonable reliance by Mr. Nemirovsky on those statements. On the contrary, he admitted on the stand that his only supposed reliance on it was when he installed ball valves on the system to make it easier to fix. He did that in 2016. And he knew by then about Mr. Vona. He sent an email about Mr. Vona on October 19th, 2015. That's on volume 3, page
Can
429.
I get the second
So-
part of the question answered though, before we lose you, because you're way over?
I'm sorry, Justice Kafka.
Could I get the second part of the question? Because I think you got an uphill battle on misrepresentation, but it may be a limited damage recovery. I'd like to understand what the damages that flow. If your client misled him, I just want to get a sense of what, I take it the verdict is not whatever these multi-million dollars is, but tell me how you calculate damages in this context based on misrepresentation.
The only damages claimed, Justice Kafka, for the statements about, is this environmental or not, was based on the fact that Mr. Nemirovsky hired experts to investigate. This is on page 26 of the red brief. He hired a lab that charged him, I believe, $14,000. That's on page 214 of volume 2 of the appendix. And he hired Boston Environmental to do some testing. They charged him $8,000. That's page 214 of volume 2 of the appendix. So we're talking $22,000 for that.
The big money is the replacement cost, right?
The big money is the tear out cost, tearing out the entire system.
Implied warranty, it's supposed to be X, and to replace, you got to tear out.
Okay, if we're back to
So-
the implied, I was trying to answer Justice Kafka's question about
That's the other half
misrepresentation.
of it is, where's the money?
Yeah, I'm just trying to get a sense. Do you just subtract the whole replacement cost? If, again, say you win, I'm giving you the possibility you win on your component part thing, but you lose on misrepresentation. And he suffered a lot. Yeah, he's misled by you guys. He doesn't, I'm trying to understand, does he get emotional distress damage? What is, you're saying he only gets the price of the cost of investigation?
I only got partway through it.
Got
So for the statements about it being environmental, the only damages, the only reliance interests stated were the hiring of the lab and the experts. For the statements about there not being other issues in Massachusetts, the claim, what he said was that he was looking for the cost of putting in the ball valves. We don't think he's entitled to that because there couldn't have been any reasonable reliance by that point. He knew about Mr. Vona.
Okay,
The
but
cost of that was approximately
but again-
$235,000. I believe that's what was claimed.
I mean, because he
Now-
knows about Mr. Vona, who is having lots of problems out there and is angry. he can't replace the system is because of your misrepresentation.
Oh, there was no suggestion, and even the Superior Court found this, that the entire tear out cost for replacing the whole system
No,
would be justifiable by
I
misrepresentation.
saw Justice Cowan subtract. I'm just trying to get a sense of the total damages in your case is minimal. We only have a misrepresentation case, even though it strung him along for a couple of years, not figuring out what the real problem was.
Well, I think the damages, you would certainly have to take out the tear out costs because there is no claim, and I don't think this is disputed,
Mhm.
that the tear out costs could be justified by misrepresentations, even assuming that they would ground liability that were made 6 years and longer after the initial system was put in. Even had there been no misrepresentations, he would still have the same system with the same styrofoam pans. So if there's no liability on the implied warranty, which of course there shouldn't have been, he would be in exactly the same system situation with respect to the system. So the only possible further damages from misrepresentations would be based on what reasonable reliance was taken based on that. And even the Superior Court, and I think even the
can I
plaintiff
ask
agree
one
it's
last
not 2.8.
question? One last question on that. If he had learned earlier that there was a problem with the system, could he have brought suit within the statute of limitations to challenge the styrofoam? Or there's no connection between the misrepresentations and losing the chance to sue over the styrofoam?
No, I don't think there's any connection there. There's no accusation that there's a connection there. There isn't any sense that anything that DACA or Stebbins Duffy, which are the two defendants accused based on the original purchase, there's no suggestion that they made any representations or that they engaged in any kind of inequitable conduct that would have told the statute of limitations. The only accusation of misrepresentations against Daikin North America, which again had no role in the choice of styrofoam or the installation of the original system.
Okay, thank you.
I thank the court for its attention.
Okay, Attorney Messenger.
May it please the court, Jim Messenger, representing the plaintiff, Ofer Nemirovsky. Mr. Moran is with me and the plaintiff is in the courtroom today. I'd like to go a little bit out of order in my outline to address one point, which I think is critical. There was a lot of statements in the brief and an argument that everything is caused by the styrofoam pan. And I'd like to address that briefly. It is a claim of implied, warranty for fitness for ordinary purpose. The jury was charged, and it was about the coils. It wasn't about the pans. The case against Daikin NA was about the coils. The jury was charged that in order to find implied warranty of merchantability, it had to find that the coils were defective when they left Daikin NA's possession. And that's at Appendix 3, 174. The jury came back and found breach of implied warranty of merchantability, implying that necessarily that the coils were defective. That
What is the evidence
The
that the
evidence is-
coils are defective?
the evidence is this, Your Honor, in 3 occasions, plaintiff's expert testified that the reason the coils did not perform as intended for the ordinary purpose was because of galvanic corrosion. And those 3 sites are Appendix 2, 324, Appendix 2, 331, Appendix 2, 334. The evidence further established that and what galvanic corrosion means is that because there's 2 metals,
She did go to MIT. She probably understands it, but maybe the rest of us
Yeah, the rest
don't.
of us don't understand.
I mean, the metal combination caused the coils to pit and then leak, and they wouldn't work. When the coils didn't work, the system couldn't work. The expert did testify that there was a separate problem with the pan, and that if the pan worked, that could have helped alleviate the problem.
Can
But
I
the
ask a
core-
very
the core
basic
problem
question?
was
On the
with
coils, for a second,
Yes.
are they some kind of very standardized product? I mean, again, I didn't go to MIT, but the coils here seem to be, these particular coils are designed for this particular system. I take it because of the size and other things, but are coils just basic building blocks of this kind of machinery out there and clearly work normally? I mean, I understand that they're integrated into the system, but is there anything unusual or defective about these coils? Are these just standard, machine parts that work in almost?
Yes, they were defective, as the expert found, because of the bimetal composition. Coils are to answer your question, coils are a standard part of an air conditioning or HVA system. There was evidence that some coils are not comprised of two metals, and I'll find that in a second. Show where my reading glasses, but there was evidence in the record of that, and I just wanted to clarify that right away because I think that's important for the court to know.
I want to make sure that I understand it though, because I thought that the bimetal composition was a problem because you had a drain pan that was styrofoam instead of metal. So my question, I guess, is, well, if you had a metal, the right type of pan, would there ever have been a bimetal composition problem with the coils?
The evidence was that if you had a proper pan, the corrosion would not have been accelerated to the point that it was.
I know, but that's sort of like a meet the press answer. Or as the judge I clerked for used to say all the time, this isn't meet the press. If there was not a styrofoam pan, but the appropriate type of pan, would the bimetal composition problem exist?
Well, I'm just going to refer to what the expert said. He said it did accelerate the problem, and he said that if there was a different type of pan, it could have grounded, which would have greatly relieved the corrosion. But at its core, the coils were corroding, and they did not fit for the. They were not fit for the.
I got that. You got to have it's in this system, and it's built to work in this system. I get that, but I'm still not sure what the answer is to that question.
Well, my response to that would be that the jury was presented with expert testimony that pointed to problems with the coil. It also pointed to problems that the drain pan could have, if differently designed, relieve that. The jury was instructed to determine whether there was a defect in the coils when it left the manufacturer's possession. It came back, it found there was. That went back to the trial judge, who twice, she denied a directed verdict in J&OV. She basically upheld the jury's view. And with respect to this motion, respectfully, what they're doing is kind of interpreting the evidence as they want. They're picking, and both sides could cherry pick the expert's testimony. It's possible to do. But the job, respectfully, I would submit the job here is for the jury. After listening to a 2.5-week trial, both sides of the experts, they were instructed to make a finding whether there was a defect or not, or they instructed that that had to be an element of the claim. And they came back and found that there was a breach of implied warranty of merchantability. And whether you can pick at the evidence and say it could have been clear or whatever, the jury heard it all. They evaluated, they observed the demeanor, and they determined that there was a breach of implied warranty of merchantability, and that they were instructed to find that they had to find a defect with the coil, not the pan. The second point I'd like to make.
I'm sorry, can I just have
Sure.
those record appendix sites again? So you're saying it appendix
Yep.
2, 330, 331, and 334 is where I'm going to find testimony that the coils themselves were defective.
A2 324, A2 331, and A2 334. That's correct.
Thank you.
There was also testimony that in terms of the fitness for its ordinary purpose.
But just before you switch to your second point, and I don't mean to cut you off.
That's right.
So, but the jury is, because, and I think your waiver argument is in part based on the fact that the jury isn't keyed into this point that something in an integrated system can fail that's fine because some other part of the system is putting too much pressure on it. I'm oversimplifying, but this issue isn't joined for the jury, right? The jury knows the coils fail, but the jury isn't, and the jury has also been presented by your expert who basically says the styrofoam puts this additional, the science I don't understand, Justice Wendland is going to have to explain it to us, but puts additional pressure on the coils and then they fail. But the jury isn't told, because no one brings it to their attention, this whole point about component parts. It's not a focal point of any instructions or anything, because no one's really figured this out until later. Is that right?
Yeah, so address the waiver issue.
Yeah. Is that correct? Is that basically, am I accurately, because I haven't read this trial transcript yet,
Okay.
or this whole enormous record?
As I believe it was pointed out, it was not raised, and the answer was not raised during trial. It wasn't raised.
But no one goes to the judge. Judge, you gotta explain, restatement third, this whole back and forth here, so that the jury understands this issue. That's not really presented, right?
Well, so rather than me characterizing, we quoted in our brief the argument made, which, and I'm not sure I'm going to quote it exactly, but effectively was there wasn't proof. It was a proof issue. I would submit a components part doctrine is a legal doctrine, and that it's not the same thing to raise that there wasn't proof of a defect in the coil as in raising the component parts doctrine. And I agree with you. It could have had all sorts of impacts on how a jury was charged.
Because the jury is presented with a simple choice. Is it the coils or is it the styrofoam, right? Or,
Against Daikin and A, they were presented with the choice, were the coils not fit for their ordinary purpose, period.
Right.
And there was a case against the DACA and Stephen Stuffy, which was directed
and that
before
was
it went to a
directed,
jury for
and
verdict.
it was directed on the statute of limitations.
Under statute of limitations.
So
But
the-
the only question that went to the jury on Daikin and A was, were the coils defective? I would not, were the coils defective? Were the coils not fit for their ordinary purpose?
That's
And
because the styrofoam was you couldn't win against anybody on the styrofoam because the
I mean,
statute
the
of
way I
limitations.
view the record is that the issue was the coils. I'd like to briefly touch on two other points with the time running out. We make the point that in a breach of contract UCC case, there is no requirement. You have to show the goods are not fit for their ordinary purpose. And that was conceded here. Their own expert admitted that a leaking coil is not fit for its intended purpose. Moreover, page 23 of their brief, they admit they were corroding prematurely. It's not disputed that when they corrode, the system doesn't work. But their argument is you have to prove the defect that caused the coil not to be fit for its ordinary purpose. We did that, but I think preliminarily the court should, at least understand one of the arguments we're making is that in a contract case, there's no requirement to prove the defect that caused the good not to be fit for their ordinary purpose. And we've cited at pages 35 and 36 of our red brief, several cases where courts have specifically held that in a contract implied warranty case, you don't have to prove a manufacturing defect that caused the good not to be fit for its ordinary purpose. And there's no dispute here. These goods were not fit for their ordinary purpose. On the waiver point, very quickly, the counsel made the argument.
Is that true? I mean, so I sell a coil, it leaves my warehouse, it's perfectly fine, not defective at all. And then the mechanic who installs it drills holes in it, so it now leaks. Am I on the hook for that?
The plaintiff would not prevail in that circumstance.
Because why? How is that different?
Because it has to be, unchanged. It has to be defective when it left the seller's possession.
Right, and isn't that Daikin NA's point is that when it left them, it was fine. It was only when you put it in with the styrofoam pan that the holes were drilled in it effectively.
No, I don't believe that's their position, and it's not the fact. I mean, the system was manufactured by the parent company. It included the pans and the coils. They were designed to work with one another.
Sure, but that claim is gone,
But-
right? Statute of limitations left on that one.
But our expert testified and established that the problem, the defect, was in manufacturing. It was the bimetal composition. There's no claim in this case that Mr. Nemirovsky, changed the coil or reconfigured the composition of the metals or drilled holes in it.
Right,
There's
no, no,
evidence of
my
that.
analogy is the pan is drilling the holes in the foil.
I don't believe that would be
Effective- a
supported
coil,
by
effectively.
the evidence in the case or the expert testimony from either expert. There's no claim that the pan caused the damage in the coil. I mean,
Oh, I thought there
there's
was. I thought-
claims that there's.
But the
I
expert,
thought that was the whole thing about the
Well, that's
expert.
one thing I want to point out in the testimony that's clear that, what the expert said was that the pan worked properly, the electrons could have been grounded. But he didn't claim that this was that this somehow changed the coil after it was sold. I think it's abundantly clear in the record that the jury found and was instructed that the coil was defective when it left Daikin NA's possession. And we put on evidence, we didn't have to, that the problem was the bimetallic composition of it. It wasn't like the plaintiff did anything in the installation. The plaintiff didn't even install it. But I mean, there wasn't like.
No, no,
any
I'm not saying the
evidence.
plaintiff did anything. And I'll have to look at the record. My understanding based on just the briefing was that the styrofoam pan caused a moisture-filled environment that was not grounded that then caused the metallic coils to leak.
That is perhaps what the expert said.
And you're
Uh,
saying
there's-
instead, your expert said, it's the fact that it's composed of two metals that is the cause of the leak.
I hope I'm answering you directly. What I'm saying is that it is true that if the plaintiff changes a component after it's sold and it is not fit for its ordinary purpose, a plaintiff can't bring a claim. In this case, there's no evidence that the part wasn't defective when it was sold.
Yeah, I guess I'm trying to ask a different
And I-
question. My question is, what is causing the failure of the coil? What is the evidence of what's causing the failure of the coil? And it sounds like they're saying it's the styrofoam pan and you're saying it's the two metals.
Yes, we're saying that the cause of the problem is galvanic corrosion, which causes pits in the coil, which causes leaking.
Which would have
causes them to
happened with
dump.
any pan, right? Because you said if it was a metal pan, it would have just happened more
The
slowly.
expert testimony was it accelerated the process. And the expert testimony is a little bit all over the place. Obviously, jury's going to view it as it did, but I think the important point is the jury heard both experts and was instructed that they had to find it was defective. The experts explained why it was defective. It was the bimetallic composition. There was definitely testimony about the pan could have properly constructed, allowed the electrons to go to ground and avoided the problem or greatly alleviated. There was also testimony that the pan accelerated the corrosion, but I don't believe there was any argument and there isn't
I mean,
any
these are
evidence.
mechanical parts, right? Eventually they will fail. The acceleration is the problem, right? They don't guarantee them for life. They guarantee them for, X number of years,
They're 10
right?
10 to
What is
15
causing the acceleration is critical.
Well, yeah, I'm going by what the experts say. The experts say it's caused by galvanic corrosion. I identified the sites.
Yep.
That's the core problem. That's the instant problem. If I could briefly, and I know my time is running out, but
Can I, before you leave, I would like you, I understand you have a sufficiency, I'm over here, a sufficiency argument that you may win, that the part is defective. But I'm curious, can you address comment E and explain, say we disagree with you and we find that the coils are fine and the problem was the styrofoam. Do you still win because there was this substantial participation in the integration of the design here from this record?
we did not brief that point, but you're correct that here, unlike a lot of the cases cited by the defendant, the parent company manufactured the coils and the pans. What was sold by the marketing arm of the company was just a replacement part. So, clearly the pans and the coils that were sold and the replacements were all, they were all designed together to work together. And that's what the trial court judge found.
But you're not arguing piercing the corporate veil.
I'm not arguing piercing the corporate veil.
But this record, which is again huge, are we gonna learn about how they built this, how they designed this company and how they put together the coils and the styrofoam? Is that in this record, or
There's some evidence in the record,
Mhm.
it's not extensive or expansive, but there is evidence of the relationship that the manufacturer has affiliates. They could have chosen just to sell it themselves. They formed an affiliate to sell replacement parts. They formed another affiliate to do the maintenance of the unit.
did they have some umbrella that coordinated all of this?
I
It's not in the
don't know
record.
that I can answer that question. I
Okay.
just don't want to give you incorrect information.
that's fine.
I'd
I
be
could just
kind of
ask you one last question about getting from $9,000 to $6 million. Why is the answer rip up the system and put in a new one?
Because
Measure of damages.
right. In this case, in the context of this, you have, there were actually 17 coils that failed. 3 of them were sold, or 4, I believe the judge said, by Daikin and A. You have a history for, 5 or 6 years where the system is consistently down, number one. Number two, you have a series of misrepresentations, where they're basically telling the homeowner, it's your fault. It's your house has unique environmental factors. And their solution in their brief and today is, well, you should just wait. And every time a coil fails prematurely, you should, once a coil fails, you don't have heat in the winter and you don't have air conditioning in the summer until it's replaced. And their solution of, okay, just kind of handle that, be without heat for a couple of days, be without air conditioning for a couple of days, and just keep replacing them as they fail. That's not the benefit of the bargain. It was foreseeable in these circumstances. And these are unusual circumstances, but when you have a series of misrepresentations, blaming the homeowner, a series of coils failing, significant frustration about not having heat or air conditioning, and there's no other solution anybody's provided except every time a coil fails, be without heat or air conditioning, wait for us to come in and first of all, locate which coil it is and replace it. That's the only solution they're offering. In those circumstances, the cost of removal and replacement was foreseeable. And it was also, and the jury was instructed, there was no challenge to the jury's charge on damages. It was instructed that you can award foreseeable damages and you can award damages to give the plaintiff the benefit of the bargain. And those two circumstances, or those two charges, given the circumstances in this case, which are egregious. I mean, 93A was awarded because of the circumstances.
Can I ask one last question on the record? Was the new system put in? Is that in the record?
It's not in the record.
So we don't know whether this new system has been built or not. This is the damage is awarded, but we don't know whether this house is operating under the old system or a new system.
There's no evidence in the record that a replacement system has been put in. We did brief the issue that courts have consistently held that you do not have to.
No, I get it. I
Okay.
understand that, but it's just
But
an
you're correct,
interesting.
there's no evidence in the record that the system was replaced at this point, and the award hasn't been paid.
Right, I got you.
And we haven't gotten the $10 million either.
Thank you, counsel.
Okay, thank you.
Chief Justice Bud, may I request leave to file a letter both to address Justice Cypher's question and also some new assertions about the record that I think warrant a response and might be useful to the court?
What was Justice Cypher's
I
question?
have a question about the record, a reference
Oh,
to the volume 3, page
Oh, about-
141. Is
oh, you didn't answer that?
that what you mean?
I tried to answer it, but to the extent Your Honor
Oh.
would like something further, that's why I'm asking leave to file a
I
letter.
thought you did my question is really, if the transcript's a part of the record, I'm fine. But often they're not, and your transcript for 3/141 is in your record appendix. So-
Yes, the transcript is in the record.
Okay.
In that event, because there were new assertions made about the record that we haven't had a chance to respond to, I'd request the leave to file a letter addressing those.
Okay, yeah, you can go ahead and do that. And then if you want to respond to it, you have the right to do that as well, okay?
Thank you, Your
All
Honor.